Okay, good morning.
Good morning.
Welcome to an oral argument session via Zoom of the 5th District Court of Appeal. I'm Judge Eisnagel. I'm joined today by Judge Harris and Judge Wozniak. Please keep in mind that the argument today is being streamed live and is also being recorded so that the public can access it. And with that, we are here at the 10 o'clock oral argument session for case 2059 Norman versus Johnston. And with that, the appellant can proceed whenever you're ready. If you would, though, tell me how much time you'd like in rebuttal, and I will try to help you. I'll try to give you a warning when we get there, but you should watch the clock as well. So,
thank you, Your Honor. Robert Foster. I represent the appellant, Frank Norman, the appellee, Nancy Johnstone is represented by Sidney Shoshone. I would like to reserve 6 minutes for my rebuttal. With that, I would like to begin. Today, you are presented with two questions. The first is, when there is a mortgage on homestead property titled solely in the name of a married individual and on his homestead property, can that mortgage attach to the property and be foreclosed when it is not signed by the spouse of the owner? The second question is, how is the court to apply payments when there are many loans and no effective allocation made by the parties when payments are made? Turning to the first question, the answer is not complicated. Frank Norman had a relationship with an individual named Donald Johnstone, the deceased spouse of the appellee, Nancy.
Counsel, I'm sorry to interrupt you. I think there is a preliminary issue here, and that's the issue of standing.
I don't think that issue was raised at trial, Your Honor.
Well, counsel, let me. In your reply brief, you say it wasn't preserved.
Yes.
But when has the rule on preservation been applied to an appellee? That is a rule that's, in my experience, always applied to an appellant, and I'm unaware of any case that applies it to an appellee.
Well, I'm not prepared to argue that point, but Frank has standing to contest the mortgage on his homestead property, regardless of whether it is his wife's protection. The Constitution protects the homeowner and his heirs, and that those heirs are Virginia Norman. He has the right to protect those heirs, has a duty to protect those heirs. So
Mr. Foster, how does the fact that Virginia Norman, the wife, defaulted in this case, and by a default admitted the allegations in the plaintiff's complaint? As far as I believe there was an allegation that the property was non-homestead. So that seems to be contradicting Mr. Norman's position on this issue. So how does that play into this?
The property is homestead property. There's no question about that. The only time we said it was not is when we made an admission in the initial pleading that the property was non-homestead. In their initial paragraph, the property was a non-homestead, and we acknowledged that for jurisdictional purposes. However, the issue was tried by the court. The court actually found that this was Mr. Johnstone's homestead. There was a pre-trial statement provided to the trial court in which that particular issue was to be tried, and we agreed that it would be tried during the trial.
Counsel, is the provision, is the constitutional requirement that the spouse also sign, is that to protect the spouse or to protect your client?
That is to protect both of them, because my client is the owner of the property, and he is to put his The Constitution says the owner and his heirs. Now, the protection afforded to Mrs. Norman comes through the protections afforded to Mr. Norman. He cannot devise that property. He cannot mortgage that property without her. He can't mortgage it, deed it, or lease it without her joinder, her signing the actual document. But it is
that's to protect her, isn't it?
protection as his spouse that provides for her interest in the property. He
Right,
cannot.
but you keep talking about her interest and protecting her. How does her signature, the requirement for her signature, how is that to protect your client? How is that your client's right that's being protected?
Because the Constitution says it is.
Where does it? Well, okay, where does it say
says
that?
he cannot he cannot alienate the property without her signature. And it is his property that we're worried about alienating, and it's his property that is protected.
Right. But counsel, it says he can't alienate it without her signature. That sounds like it's to protect her. And I'm just trying to, what I'm asking is, it sounds like it's to protect her, but what's your argument that it's really to protect him? Protect him from himself? Hey, we're not going to let you alienate this without her signature because for your client's protection?
It protects him because the Constitution says that it is protected. He cannot do it. He cannot alienate. It is a restriction on him, and he is protected, and he has the right to enforce the constitutional protections that are granted him.
So the limitation.
He signed the document, right? He signed the mortgage. At the time, he could have said, well, I have a wife. She may live in a different house, but she should probably sign this too. That didn't happen. So all of the risk, I guess, goes on the lender in your position if the wife didn't sign it, even though the husband knows he was married, obviously.
Is it the husband's duty to get the contract or the mortgage signed by the spouse, or is it the maker's?
Right, and does all the risk
John's
go on
point.
the lender, I guess, is what my question is. So the lender's just out of luck.
I don't understand you, ma'am. I'm sorry.
I guess I'm asking, is the mortgage void because the wife did not sign this?
Mortgage cannot attach to the property and cannot be enforced in foreclosure without the wife's signature. That's in Crawford versus, give me a minute. Crawford versus Fannie Mae, which is a decision by this court in 2019. If that
And so the lender has no remedy then, cannot, as far as the property goes, cannot foreclose on this. It's all on the lender.
That is what this court has said, and that is what this court said in S. Wall versus Stillwell Corporation.
Counsel,
This court said that
if you
it cannot attach if the wife has not signed it. So he has the
counsel,
right.
there's no, we've all, I'm sure that the panel has read the constitutional provision many times, including for this case. I think the question is, and so there's no doubt that the Constitution requires a signature by the spouse. That's not a question, I don't think. What is a question is whether your client can enforce the spouse's requirement that she sign. I think that's the question. Do you have a case, any case in Florida, saying that your client can enforce the lack of a signature, if you will, by the spouse, as opposed to the spouse enforcing that?
No, I do not have such a case. I was not prepared to argue such a case. That case was not raised, that point was not raised at trial. It was not raised very lengthily in the argument in the reply brief or the answer brief. I was not prepared to argue that point, and I don't think it should be considered by the court at this point.
Well, counsel, there's standing requirements at the trial court. There's also a pretty long line of cases requiring standing at the appellate court level as well. There's a long line of cases saying that a party cannot appeal a judgment that does not, affect their rights. And I'm sure I could have said that more eloquently.
This
So
does
there's standing.
affect you. Your Honor,
Okay.
for me, this does.
Well, I
affect
think that's
you.
the question. How does it affect your client's rights as opposed to your client's wife's rights?
Because my client has a right to enforce the provisions of the Constitution that protect him, that says that he cannot mortgage the property. Therefore, Johnston was operating under that law. And when
But how does, I guess that's the question though, right? That what you just said begs the question. How is it your client's right as opposed to the wife's right? How does it protect your client? It clearly protects your client's wife, clearly. But how does it protect your client to say the Constitution says your client cannot sell the property without wife's signature? That seems to protect wife, not your client.
It may protect the wife, not my client, but Johnston has the duty to ensure that the mortgage is proper. And when the mortgage is not proper, my client has the right to use that to defend himself when they're trying to take away his homestead. The homestead law is to be liberally construed under the case law in Florida. And in this case, it means that that Frank has the right to defend his rights in this property when Johnson does not comply with the provisions of the Constitution. Yeah, go forward.
Yes, please.
Well, in Crawford, this court says the Florida courts have consistently interpreted the Constitution provision as requiring spousal joinder in the execution of mortgage on homestead property in order for the mortgage to encumber the property to be enforceable in foreclosure, even where the only signatory spouse is the owner of the record of property deed. It goes on in S. Walls versus Stillwell Corporation and stated as a matter of policy as well as construction, Florida courts have consistently held the exemption should be liberally construed to protect the homeowner. In this case, Frank Norman. Further in that case, the court stated the purpose of the homestead is to promote the stability of the state by securing to the householder a home so that the homeowner and his or her heirs may live beyond the reach of the financial misfortune and demands of creditors who give credit under such law. Johnstone was a creditor who gave credit under this loan. Under the cases by this court, the homeowner has the right to object or to defend on the grounds that Johnstone did not comply with this law. The mortgage
You cited a Crawford case earlier in the argument. I'm not seeing that in your brief. Could you give us the citation?
On Walls versus Stillwell?
I think you said Crawford.
Crawford, yes. Crawford citation is, and I think I did cite that. At any rate, it's at 22.
Not in your table of citations.
226 Southern, 1274, 5th DCA, 2019.
Southern Third.
No, Southern Second.
Thank you.
No, that would be Southern Third. I'm sorry. That's Southern Third. Let me see, make sure.
Can you repeat
Given the
the
date it would
citation
have.
one more time, please?
Pardon?
Can you repeat the citation one more time, please?
It's Crawford versus Fannie Mae, 266 Southern Third, 1274. 2019, 5th DCA.
Thank you.
He did not sign the mortgage, and as such, it cannot attach to the property, and the court was in error in ordering the foreclosure. And
Counsel,
I
you're
need
into
some-
your 6-minute rebuttal. You can keep going if you'd like, but I just
No,
letting
I'd
you know.
rather have the rebuttal, thank you.
All right. All right, then you'll have 5 minutes and about 40 seconds for rebuttal. And
Thank
with
you.
that, we'll recognize the appellee whenever you're ready, counsel.
Thank you, Your Honor. May it please the court. My name is Sydney Shoshone and I represent the appellee, Nancy Johnstone. As Mr. Foster stated, there are two issues pertinent to this case. The first is that the trial court correctly found that the property is not Mrs. Norman's homestead, and therefore her signature was not required on the mortgage. And the second is that the payments made by Mr. Norman were allocated properly. To begin,
Just based on the language of the Constitution, that first statement that you made, that doesn't seem to really sort of meld well with the actual language in the constitutional provision.
yes, Your Honor. So as you said, Article 10, Section 4 does say that the owner of a homestead, if married, must be joined by the spouse to alienate the property. I think the issue here is that a mortgage is a contract to sell a home in the future if a debt is not repaid. So even though the Constitution limits it to have the wife join, it does not forbid the owner from unilaterally signing the mortgage, as long as in order to make the mortgage effective, the wife either joins in the mortgage, waives her right to the homestead property, or abandons the homestead. And that is actually found in the case of Pitts versus Pastor, which is a second DCA case that the trial court heavily relied on when reaching its conclusion. In that case, Mr. Pitts signed a mortgage on a homestead property and his wife did not. Later, the couple divorced. Mr. Pitts remarried and moved his new wife into the home. Mr. Pitts argued when the Pastors went to foreclose on that mortgage that because his wife did not sign the mortgage, that the mortgage was invalid. However, the court found that Mr. Pitts was able to enter into the mortgage and said that the purpose of Article 10, Section 4 of the Florida Constitution is achieved if the mortgage is ineffectual as a lien until such time as either the spouse joins in the alienation or the property loses the homestead status. So in that case, when the couple divorced, the property lost its homestead status as to the wife, and the court said that this did not disadvantage the wife. Now, the facts of that case are actually even more favorable to the appellee's case here because there was no homestead status to begin with. As you already stated, Mr. Norman admitted that both in his answer, in his amended answer, and Mrs. Norman admitted it by way of default. And in fact, on page 6 of Mr. Norman's appellate brief states, the trial court found that the property at issue is not the protected homestead of Norman's wife. Therefore, her signature was not required on the mortgage. The trial court is correct. End quote. Now I know.
Counsel, you acknowledge that. I mean, that while the reasoning there certainly has some logic to it, it's not directly reflected into the constitutional language itself, right?
Correct, not in that provision, Your Honor, although constitutional provisions should be read harmoniously, as well as looking at the case law, which is both persuasive and logical here. And I know Mr. Norman does bring up in his reply brief that the trial court incorrectly relied on this Pitts versus Pastor case because of the 1985 amendment to this Florida constitutional provision. However, I just want to bring the court's attention to footnote 10 of that case, which states that the 1985 amendment of this constitutional provision is not involved in this case, but it would not appear to alter the reasoning of this case. And this case has stood as good law for over 30 years now. We can also look at cases in other Florida district courts.
Excuse me, I was on mute. I was trying to interrupt you. I
Oh, okay.
apologize.
Yes.
The amendment in 1985 was the amendment that changed it from saying head of household to natural person owning the property. Okay.
Correct.
Thank you.
Yes. So we can also look at cases in other district courts in Florida regarding abandonment. They're very instructive here. Those cases state that when a homestead status is established, it continues until the homestead is abandoned. And where a wife has no homestead interest in a home owned solely by her husband due to abandonment, she cannot later assert that right. And as we know here, there is no abandonment because the wife, as Mr. Norman said in his brief, has probably never lived in the subject property. And the homestead protection requires actual occupancy with an intent to remain there. So additionally, we can look at other jurisdictions that have nearly identical homestead protections to Florida. They also hold that abandonment would end the homestead status as to the property. And those jurisdictions are Mississippi, Missouri, Vermont, Alabama, Texas, Oklahoma. And as Mr. Norman stated, the purpose of the homestead protection is to promote stability and welfare of the state by securing a home for not just the householder, but the spouse in case of financial misfortune or death of that spouse. That purpose is fulfilled here. Mrs. Norman is protected. She owns her own home in Homestead, Florida, where she claims homestead protection on. The ruling of this court will not leave her homeless and become a burden of the state.
So this entire argument is ignoring your opposing counsel's argument that, look, it's not just her right. It's also Mr. Norman's right.
Yes, well, Mr. Norman,
you haven't addressed that at all. So why don't you talk to us about that?
Yes, Mr. Norman is an adult. He can mortgage his property. I'm sure he is aware of the consequences of doing so.
Well, counsel, speak to us in terms not of public policy, but speak to us in terms of the law and the Constitution. Because certainly the Constitution could say that all those things you just said, I suppose, but the Constitution says what it says. So under the Constitution language that we're bound by, why isn't it Mr. Norman's right as well as his wife's?
Well, going back to the Pitts versus Pastor case, there, the husband, who was the conveying spouse, was the one arguing that it was his right to make the claim that the mortgage was void. And there, the court found that it wasn't. It was the wife's protection. She lost that status when they were divorced. And so the mortgage was valid and the foreclosure continued.
Counsel, that case isn't binding on us. That's out of the 2nd district. Why is that case correct? Why is that the correct decision? That case
although isn't binding, is persuasive. It's logical. It stood as good law for 30 years. And I don't find any other cases stating the contrary. So as we can see here,
that's sort of conclusory, right? Why is it logical and why does it make sense? If we didn't have Pitts versus Pastor, what would the arguments be?
Right.
That
so
it's not Mr. Norman's right.
Right. So if we're looking at the other constitutional provisions regarding the homestead protection, and we look at the purpose of the homestead protection, it states over and over again that it's to promote the stability and welfare to protect the spouse. Now, I think it was Snyder versus Davis that Mr. Foster cited to regarding the purpose of the homestead. He mentioned that it was to secure a home for the householder as well, but this isn't a judgment here. This is something Mr. Norman did freely and willingly. So it's not as if he was not aware that this would be the consequence if he did not repay the loan.
Is there any evidence in the record that at the time the mortgage was signed, there was any intent to defraud?
So, I'm having the
evidence that there was an intent to defraud at the time.
I don't believe so, Your Honor. So yes, as I was stating, the homestead protection is designed to protect the non-conveying spouse, not so that the conveying spouse, as Mr. Norman here is doing, to protect himself from troublesome creditors. And if the court has no further questions regarding the homestead issue, I'd like to move on to issue number 2 regarding the allocation of payments. And that issue, Mr. Norman argues that in addition to his monthly interest payments, of $833.33. He was making that he also made $52,000 cash payments to prepay the mortgage, and is arguing that his other interest payments on the 6 other loans that existed at various times during the subject loan should have gone to prepay the subject loan because he did not allocate to Mr. Donald Johnstone on how to apply those payments. Now, Norman's argument fails for several reasons. The first is that Norman's monthly interest payments were either identical to the interest payments stated in the corresponding loans, or they equaled the sum of 2 interest payments added together. This showed Norman's intent by making these payments the exact amount that they were in the loans and making them at the time they were due, that he intended for those payments to be allocated to those corresponding loans. And this is actually found in the case of Randall versus Pets, which is a case Mr. Norman cited, a Supreme Court of Florida case that says a direction of payment may be evidenced by circumstances, and a delivery of a sum due on a debt is such a circumstance. Another reason Mr. Norman's argument failed is that his own payment ledger shows his intent. If you look at the payment ledger, it's at the record at 994 through 996. The only payments on Norman's record were the $833 interest payments, which are not in dispute, and the $2,000 cash payments. He never included the other payments he made on the other loans, intending them to be applied to this loan. And the trial court, at the greater weight of the evidence, did not find that these $2,000 cash payments were ever made. We looked, there was simply Mr. Norman was requiring or relying on Mr. Bird's affidavit saying envelopes were passed back and forth, but we could not confirm what was inside those envelopes. If it was money, we don't know how much money. Additionally, Mr. Norman already received credits for the interest payments he made on the other loans. When he was sued in a prior action for foreclosure and breach of note on 3 other notes that were 2 were secured and 1 was unsecured. So now he wants to use the payments he already got credit for on those loans, and now wants them to be applied to this loan as well. Additionally, with this subject loan, there's a 1.5% prepayment charge. And I just want to remind the court, this is a balloon note that did not become due until 2015. There's no evidence that that 1.5% charge was ever triggered or that Norman ever paid it. So by prepaying this subject note, it would have caused the 6 other loans that were existing during this time to go into default at the expense of this one loan. And the trial court actually stated that it found it illogical that Norman would have continued to pay the $833.33 per month on a loan that was declining in value, supposedly because he was prepaying it. It's also illogical that Norman would prepay this loan with the interest payments that we discussed, as well as and the $2,000 cash payments. That would be overpaying the loan if he was paying both $2,000 cash payments and wants the other interest payments to apply to this loan. So in summary, Your Honor, the circumstances are overwhelmingly clear that the payments were correctly applied to their corresponding loans. And nothing further, Your Honors. Thank you.
All right, and so we'll move into rebuttal. I think we got about 5 minutes, 39 seconds for appellant. You may proceed when you're ready, counsel.
Thank you. I would point out from our earlier discussion that Mr. Johnstone was the creditor under the current laws and under the Constitution, and he is the one that failed to make or have the wife sign the mortgage. Mr. Norman has a duty to protect the property and has the standing. As to the first issue, the appellee and the trial court are both confused as to whose homestead we are dealing and the purpose of the constitutional provision requiring a spouse's signature on the mortgage on that property. The property is titled in Frank's name individually. He resides there. He's a natural person under Article 10, Section 4. It is his protected homestead and no one else's. It is not Virginia's. Virginia's protected homestead is on Stone Island. And yes, Frank and Virginia can both have protected homesteads. That's in Law versus Law, a 4th District case. The law court points out that in the 1985 constitutional amendment extended the homestead protection to a natural person without any regard as to whether that person was the head of a family, and went on to say the homestead exemption is to be liberally construed for the benefit of those whom it was designed to protect. Though it is Frank's homestead, Virginia, as his wife, is the one it is designed to protect, and he is the one to protect it. Article 10, Section 4, by protecting Frank's property, his property, provides for Virginia. Frank cannot devise his homestead to anyone but Virginia, then only if there are no minor children. If Frank were to die tomorrow, he having no surviving children, the property would pass to Virginia with all the protection from creditors the Constitution affords Frank. Frank has a duty to protect that right. Frank cannot alienate the property, sell it, mortgage it, or lease it without Virginia's approval, without her signature. There's a reason for that provision in the Constitution. That provision ensures Virginia that Frank cannot eliminate her protections as guaranteed as Frank's wife in his homestead, without her knowing it and agreeing to it. The argument that Virginia need not sign the mortgage because she has her own homestead ignores the very purpose of the homestead provision to protect the homeowner, Frank, and his heirs from creditors. The trial court erred in ordering the foreclosure of the mortgage. Did Frank pay the debt secured by the mortgage in his homestead? The issue becomes whether there was an effective allocation of payments. Either Frank directs the allocation at the time of the payment, or upon his failure to do so, Johnstone makes the allocation and informs Frank as to the debt the funds are to be applied. Frank never gave direction as to the allocation. The appellee takes the position that because some payments added up to the sum of the debts that may be assumed that Frank was directing that to the correct amount on each obligation was to be taken from the payment, and there was no need to notify Frank as to how much was applied to the loan. Such an assumption is a long way from the Randall case that was cited by the appellate or the appellee. In Randall, the debtor the creditor claimed the debtor owed 2 notes, 2 mortgages. The debtor specifically denied owing anything on one, and then made a specific payment in the exact amount due on the other debt. That's a long way from the assumption that Frank intended these to be applied to a particular debt. I would point out in Randall that he adds it is equitable to apply the payment first to extinguish those debts for which security is the most precarious, Frank's homestead. It is assumed because the common figure in the checks and the common figures that debts may or may be due or overdue, they were meant to be applied to a specific debt. But the appellee fails to consider the due or overdue. At the time Frank made these payments, many times they were overdue, and the payment would be inappropriate to the proportion in the check. Additionally, Frank made payments that had no relation to anything. He made payments of $8,000, $3,600, $2,700, $500, probably in cash. And there's no indication as to how any of those were applied. There is no indication and no informing of Frank as to what loans, what sums were applied. The court erred in failing to allocate the payments in accordance with Friedlander and McElwain. Thank you, Governor.
All right, thank you, counsel. And with that, we are adjourned.
Thank you.
Thank you, Your Honor.